January 2026. Federal prosecutors drop a bombshell filing. Multiple cooperating witnesses from inside OTF are coming forward. Not random informants, but people allegedly inside the operation itself. Then leaked documents reveal these witnesses are prepared to testify that Durk ordered the violence, used intermediaries to recruit shooters, and promised a reward for murder. Here's the FBI witness footage that just shocked everyone. January 2026 hit different. Federal prosecutors dropped a filing that sent shockwaves through the case. Multiple cooperating witnesses are coming forward, not random informants from the street. We're talking about people allegedly inside the operation itself. The government made their strategy clear in court documents filed just days before the January 20th trial date. These witnesses allegedly participated in the Los Angeles violence. They're connected to Durk personally. Close OTF associates, insiders from the circle. Now turning on him.
This is their memorandum of points and authorities. So this case involves a well-funded, interesting that they mentioned up front, well-funded, an organized attempt to kill one of the defendants, Durk Bank's rivals, at a busy gas station.
What makes these witnesses dangerous isn't just what they know. It's what they're prepared to say under oath. Prosecutors revealed these witnesses are expected to testify that Durk ordered the violence in Los Angeles specifically, that he used intermediaries to recruit others to carry out the scheme, that he promised a reward for murder.
So federal prosecutors are now saying that the Chicago rapper, A, ordered hits on his own O-Block associates for failing to retaliate after the death of a fellow artist, King Von.
The filing laid it out in black and white. These testimonies will detail three distinct phases: how the plot was conceived, who was recruited and why, how money changed hands, purchase of equipment, travel arrangements funded, the full operation breakdown from start to finish. Federal prosecutors say these insiders are prepared to describe Durk's role not as some passive participant, but as the kingpin of the operation, the organizer, the financier, using OTF resources to fund a hit. The allegations include something particularly damning: a reward system. Federal prosecutors are claiming cash was offered, a financial incentive structure, payment for murder. This proves conspiracy elements under federal law, and potentially a money trail investigators have been following.
Lil Durk, whose real name is Derek Banks, is still being held in federal detention in Los Angeles following his October 2024 arrest. Prosecutors claim that Durk orchestrated a murder-for-hire plot back in 2022.
The case stems from that August 2022 attack near a Beverly Hills gas station. Saviaya Lul Pab Robinson, Quando Rondo's cousin, was killed, shot to death outside. Prosecutors are calling it murder for hire. Retaliation for King Von's death 2 years earlier, November 2020 in Atlanta. King Von was killed in an altercation with Quando Rondo's entourage, close associate of Durk. That death intensified tensions between rival camps. According to prosecutors, it motivated what happened in Los Angeles 21 months later.
In the shooting that followed, though, Quando wasn't the one who died. It was actually his cousin, Saviaya Robinson, who was killed in what prosecutors are calling this ambush-style attack at a gas station.
October 2024 changed everything. Durk was arrested at a Florida airport. Prosecutors claimed he was attempting to flee the country. Federal charges immediately filed in the Central District of California: murder for hire conspiracy, use of interstate facilities, weapons-related offenses. The indictment hit hard: conspiracy to use interstate facilities in a murder-for-hire scheme resulting in death. If convicted on all charges, Durk faces decades in federal prison. Life-altering consequences he's been fighting against for 15 months. Durk has maintained his innocence throughout, pleading not guilty to all charges. He's been in custody since his arrest, 15 months behind bars, held without bond. Multiple bail attempts denied, including a $4.5 million package rejected by the court.
The trial is currently scheduled for January 20th of 2026. There are lots of motions.
The trial date is set for January 20th, 2026, if everything stays on schedule. This would be the third delay already. Co-defendants are requesting a fourth postponement. But Durk has refused. He wants his speedy trial. He wants to face these accusations head-on. There's another layer to this. Prosecutors filed sealed documents on January 2, 2026, to protect identities of unindicted co-conspirators and witnesses set to testify. Fear of retaliation is real. They're keeping names secret until the last possible moment.
After reading that, here's what actually stands out, and it matters more than people realize. This document, it's not about guilt or innocence, it's about time. Every defendant in this case had a speedy trial clock that was already running.
The defense has already signaled their plan of attack. They're going after witness credibility hard, characterizing these cooperating witnesses as untrustworthy, self-interested. At a November hearing, defense lawyers used specific language about one witness, called them a documented liar, a manipulator, a fraud of the highest order.
Now, in that, because they're not going to go to trial now, Durk is proceeding with what's called a motion to dismiss. Durk is saying this case is bullshit, and by the way, a bunch of other inmates are saying, nah, this case is bullshit. Y'all don't got what y'all need.
Prosecutors are acknowledging this strategy. They're expecting credibility attacks. But they're saying it doesn't justify keeping testimony from the jury. Let the jury decide truthfulness. Evidence speaks for itself. Corroboration from multiple sources means they're not relying on just one person's word. The volume of evidence is staggering. 230 gigabytes of digital evidence, audio recordings included, surveillance footage, over 20,000 pages of reports documenting murder and violent acts, photographs, witness statements, medical documents. The paper trail is massive.
The second superseding indictment was filed as to all defendants on May 1st, 2025. On September 17, 2025, the court continued the trial date to January 20th, 2026.
So why are these witnesses cooperating? Simple answer. They're facing their own charges. They want reduced sentences. Immunity deals potentially on the table. Pressure from the FBI is real. Fear of life sentences changes calculations. Self-preservation instinct kicks in. And loyalty breaks down when decades in prison become the alternative. Defense attorneys argue the disputed evidence unfairly paints Durk and OTF as a criminal enterprise. Prosecutors push back hard. They say this evidence is essential for jurors to understand relationships among defendants and why certain individuals allegedly followed orders. They're not claiming OTF is purely criminal. They're arguing a subset of people associated with the group allegedly operated like a street gang when settling disputes.
Criminality. A seized audio message between two OTF associates demonstrates this hierarchy. In this message, a prominent OTF associate explains that when people call Durk for money, he gives out $500,000, $600,000 to the streets.
The January hearing will determine what evidence jurors actually hear. What testimony gets allowed? What gets excluded? The judge holds enormous power over how this case gets presented to 12 people who will decide Durk's fate. The security concerns around this trial are extreme. Prosecutors requested an anonymous jury due to threats targeting the judge and prosecutors. Supporters of the rapper have allegedly issued multiple threats. Federal authorities are taking this seriously.
Against prosecutors and judges and request for an anonymous jury. Let's talk about this. So authorities reporting that supporters of this rapper have issued multiple threats targeting key figures in the case.
The volume of threatening messages has been substantial enough that the court granted the anonymous jury request. Prosecutors documented multiple instances of intimidation attempts, providing evidence that justified extraordinary security measures for the trial.
Indeed, defendant supporters have already threatened government officials to free Durk or else face retribution. Now,
adding to the complications, Durk was reportedly caught with a contraband Apple Watch while in custody. Prosecutors allege he attempted to destroy the device when officials discovered it. Rather than accept responsibility, they claim he obstructed the investigation. This alleged misconduct while detained only strengthens the government's argument for keeping him locked up.
This is defendant Banks, this is important, chat. Defendant Banks has also shown a repeated disrespect and willingness to impede the judicial process despite admonishments from two courts about phone violation at the Los Angeles MDC. Defendant Banks has escalated his defense.
Durk's legal team has tried multiple angles. They filed a motion to dismiss the federal indictment entirely, arguing prosecutorial misconduct through the use of rap lyrics written before the crime. That motion was denied last month. They've challenged the scope of evidence. They've objected to the timeline. They've fought bail denials. But the case keeps moving forward.
He had claimed that they used lyrics to present to a grand jury who came back with an indictment, right? The indictment is the bill of charges. And they said those lyrics were recorded before the death of Lil Pop.
From behind bars, Durk broke his silence recently. An Instagram story on January 6th carried a single line against a black background. Crazy how you gotta wait until it's dark out to see who really with you. The emptiness amplified his message. No distractions, just raw thought from isolation.
To find out this, several mayors are addressing solitary confinement, notably New York City's Mayor Mamdani taking action in January 2026 to limit it at Rikers Island, and Shelby County Mayor Lee Harris. That's Memphis.
That darkness he referenced felt both literal and symbolic. After spending months in solitary confinement over an alleged Apple Watch violation, Durk's awareness of who shows up and who disappears has likely sharpened. Long periods in isolation force reflection. They reveal truth. His message tracked with themes he's explored throughout his career: survival, loyalty, betrayal. This time there was no production, no hooks, no polish, just Durk in raw form. From confinement, reminding people that real loyalty shows itself when everything goes dark.
So the feds have allegedly quietly introduced this new explosive claim into Durk's legal case.
As January 20th approaches, the stakes couldn't be higher. Multiple cooperating witnesses preparing to testify. Prosecutors claiming they can place Durk at the center of a murder-for-hire conspiracy. Defense attorneys ready to attack credibility and motive. And Durk himself refusing delays, demanding his day in court. The courtroom battle is about to begin. The cooperating witnesses didn't just implicate Durk. They set the foundation for prosecutors to target OTF as a criminal enterprise. The legal battle over Lil Durk's identity just hit a critical point. Prosecutors want jurors to see evidence connecting him to street violence. His defense team wants that same evidence blocked. January 7th, a federal judge will decide which story gets told. The defense argument centers on one claim: OTF is a legitimate music label, not a criminal enterprise. They're asking the judge to exclude key testimony and evidence that could paint Durk and only the family as something darker.
Our Durk's team was trying to get rid of OTF evidence like the structure as a gang. Remember the prosecution saying it's a gang and not just a record label?
Prosecutors aren't backing down. They're standing firm, strongly opposing the defense request. Their position? This evidence is essential for jurors to understand relationships among defendants and why certain individuals allegedly followed orders.
They're not letting the defense block this evidence quietly before trial. Durk's lawyers tried to keep certain material away from the jury, and the government responded by saying this evidence matters because it goes to intent, motive, and a pattern of behavior.
The government clarified something important in their filing. They're not claiming the entire OTF label is a criminal organization. Instead, they say a subset of people associated with the group allegedly operated like a street gang when settling disputes.
On October 27, 2025, during the November 18, 2025 hearing, the court heard argument and ruled on the matters, but deferred argument on the related motions to January 7. Consistent with the parties' stipulated trial schedule, the government provided an amended Rule 404B disclosure.
The government's exact language tells the story they want to present. Evidence shows that Durk and his close OTF associates had rivalries, discussed violence against rivals, and took violent street action to settle scores.
They saying that this evidence is directly intertwined with the charged conspiracy. Meaning, in other words, it actually helps the jury understand how the alleged co-conspirators.
To prove conspiracy, prosecutors need to establish who knew who and who reported to whom. Chain of command structure, financial connections, communication patterns. Without this foundation, the murder-for-hire charge crumbles.
As outlined in the government's opposition, the defendants cannot credibly dispute that TB and his entourage were stalked for hours across LA, and that SR was brazenly murdered by 3 of the stalkers. Remember, TB is Quando Rondo.
Durk's role in violence becomes the central question. The government needs to establish his position of authority, his ability to order hits, his control over finances, and his access to resources.
We got to bring that in because they're arguing you can't understand that answer without showing the whole entire structure. It's like, hey, bruh, they was out there fighting. What was they fighting for? Well, they was fighting because they're part of a gang. Well, they want to bring in how the gang started, how everything is basically going.
The defense sees this differently. They're attacking the government's key cooperating witness, trying to discredit them before they ever take the stand. But prosecutors have revealed they're not relying on just one person's testimony. Multiple cooperating witnesses are prepared to testify about Durk ordering the violence, using intermediaries to recruit others, and promising a reward for murder.
Not just over OTF's legitimate music enterprise, but critically, his knowledge of and involvement in OTF's violence. Consistent with the gang murder prosecutions across the country, the evidence to prove these facts will include the testimony of cooperating witnesses. So remember, there's some snitches afoot. People are cooperating. There's going to be witnesses testifying at trial.
The government knows testimony alone won't be enough. They're backing up those witnesses with physical evidence, financial records, communications, travel records, all supporting the narrative. Credit cards associated with OTF tell their own story. According to prosecutors, these cards purchased defendants' plane tickets, creating a financial trail showing the organization funded travel for criminal purposes. The day before the murder reveals coordination prosecutors say is damning. 5 named co-defendants plus an unnamed co-conspirator flying from other states to California together, convening in an LA hotel room.
So Banks is allegedly ordered to murder, and he sent these hitmen money, and he used his own credit cards to do it.
Equipment purchases followed the hotel meeting. Ski masks bought the day before, 2 sedans secured, guns distributed, including one modified to operate as a fully automatic machine gun.
But critically, his knowledge of and involvement in OTF's violence. Consistent with gang murder prosecutors across the country, the evidence to prove these facts will include the testimony of cooperating witnesses.
Text message evidence cuts through any claims of coincidence. Co-conspirator 1, texting. Co-conspirator 3, the day before the shooting. Don't book no flights under no names involved with me. Consciousness of guilt, an attempt to hide tracks.
Durk's legal team want to know when, where, and how the coded language was communicated. What were the rewards or opportunities promised for the murder?
The wonderful Wayne lyrics created the biggest controversy. Babyface Ray's song featuring Durk, recorded January 2022, 7 months before the shooting. The government tried using it as evidence of intent, but the defense fought back hard.
There's a song reference in Lil Durk's defense is Wonderful Way and Jackie Boy by Babyface featuring Lil Durk. The defense argues the prosecutors misrepresented the lyrics.
The defense called it overreach. Lyrics aren't testimony, they argued. Creative expression protected by the First Amendment. Eventually, prosecutors removed the lyrics from a superseding indictment.
Taekwon Bowman Quando Rondo. The government intends to produce or introduce evidence relating to Durk, motive, intent and preparation, and plan in seeking revenge on Quando Rondo for Quando's.
The January 7th pretrial conference will determine what evidence jurors hear at trial. Critical rulings that could shape the entire case.
The government basically laying out their whole theory on the table. They're saying nobody can seriously dispute that the alleged victim was followed for hours across LA because, it just would be difficult.
The critical questions remain. Who ordered the violence? Who directed it? How was it carried out? The jury will need to answer all 3.
To end it out, what they're saying is this isn't some made-up theory that they just came up with at all. They're leaning on federal case law to justify exactly why this evidence should actually come in. They're pointing out to prior conspiracy cases.
The case earned a complex case designation due to evidence volume and the number of defendants. This justification allowed multiple delays, all against Durk's stated wishes for a speedy trial.
And so with this kind of case, what happens is you think, oh, you're entitled to bail. No, you're not necessarily entitled to bail. There's called a rebuttable presumption that you're detained. In other words, you're detained. You got to prove. Now it's on you.
One defendant, DeAndre Wilson, filed a motion to sever his trial from Durk's. It's strategy, legal experts say. Wilson is allegedly the connective tissue linking Durk to the shooters.
No matter what it says, this is information that is filed by OTF Didi. He wants to get his case away from Durk and everybody else.
If Wilson's case gets separated, the prosecution's conspiracy theory against Durk becomes much harder to prove. The prosecution understands this threat. That's why they're fighting to keep certain evidence admissible and standing firm on their plan to call multiple cooperating witnesses. But there's another wrinkle. The defense has highlighted what they call significant prosecutorial misconduct. Death threats were made against the assigned magistrate judge and lead prosecutor, and the government allegedly withheld this information for 7 months. The timing raises questions about fairness and due process. Why not just tell the defense, Durk's lawyers ask. January 20th marks the moment when the legal maneuvering ends and the trial begins. Everything prosecutors and defense attorneys fought over for months will finally reach a jury. The cooperating witnesses represent the prosecution's most powerful weapon. Physical evidence tells part of the story, but witnesses who operated inside the organization can connect those dots in ways documents alone cannot. Defense attorneys signaled their strategy early: attack credibility, question motives. These witnesses are trading testimony for leniency, they'll argue. Durk has maintained his innocence throughout. His family released statements defending him. His legal team filed aggressive motions challenging every aspect of the government's case. But federal prosecutors don't take cases to trial unless they believe they can win. But while lawyers argue structure and conspiracy in court, Durk's day-to-day reality has been unfolding in isolation. August 29th, 2025. That's the day everything changed for Lil Durk. Not because of a court ruling, not because of new charges, but because of an Apple Watch. Since that day, the Chicago rapper has been locked in a cell barely big enough for a bed, toilet, and sink. 23 hours a day, every single day, no commissary. 1 phone call a month, no visitors, just concrete walls and silence.
Let's go right here to the crux of the situation. Declaration of Counsel. Christy O'Connell state and declare the following. I'm an attorney licensed practice in the district, and I am one of the attorneys representing Durk Banks in the instant matter. Since August 29, 2025, Mr. Banks has been confined to the segregated housing unit.
And it's all because of what authorities claim was an unauthorized device. An Apple Watch that somehow made its way into his hands at the Metropolitan Detention Center in Los Angeles.
This is all the Durk's team. Y'all know the crew. Drew, Jonathan Bateman, Christy O'Connell, and this is for Durk Banks. United States District Court, Central District of California, United States versus Durk Banks.
But here's where things get murky. Federal regulations say when an inmate gets put in the segregated housing unit, they're supposed to get a proper disciplinary process. The Unit Discipline Committee reviews the incident report within 5 work days. They decide on sanctions. There's supposed to be accountability. That hasn't happened. Not in 5 days, not in 5 weeks. It's been 131 days, and Durk still hasn't received the hearing he's legally entitled to.
Defendant Durk Banks' request for status hearing regarding extended SHU detention without process.
His attorney, Christy O'Connor, isn't mincing words. She filed a motion on January 7th asking for a status hearing, arguing that Durk's prolonged isolation violates federal regulations, maybe even the 8th Amendment. The conditions inside that cell are brutal. 1 phone call monthly, no commissary access, no in-person social visits, just concrete walls and isolation. That's the life. The psychological research on extended solitary confinement paints a disturbing picture. Depression, anxiety, self-harming behavior, social withdrawal, loss of identity. And Durk's been living in these conditions for over 4 months without proper review. But the most frustrating part? Nobody can get their story straight about why he's still there.
The original cause for his SHU placement was an allegation that he was in possession of an unauthorized Apple Watch. Since August 29, 2025, Mr. Banks has not received the process that is prescribed by law, where an inmate is accused of an infraction, C-28 CFR
October 2025, an MDC attorney tells Durk's defense team that his celebrity status has nothing to do with his SHU placement. They want it clear, this isn't about him being famous. December 22nd, the warden tells a completely different story. Suddenly, Durk's presence poses a threat to security and the orderly running of the institution because of the high-profile nature of his case. So which is it? Is his celebrity irrelevant, or is it the entire reason he's isolated? Here's what makes that contradiction even more damning. Before August, Durk spent 11 months in general population, 11 months without a single incident related to his celebrity status or his pending case. No problems, no security threats. Then suddenly, an Apple Watch appears, and he becomes too dangerous for the general prison population. The conditions he's enduring aren't just restrictive, they're designed to break people down mentally.
The deleterious effects of extended solitary confinement on an inmate's psychological well-being are well documented. See Rittier, ETAL, or Psychological Distress in Solitary Confinement.
MDC officials claim they've been conducting monthly segregation reviews with Durk present. His attorney says that's a lie. According to O'Connor, the first time Durk was actually offered the opportunity to attend a segregation review was just last week, and that only happened after she sent the warden a discovery request, specifically asking about these alleged meetings that never occurred. They got caught fabricating records. The government's explanation doesn't add up either. Prosecutors told the defense that Durk's SHU placement isn't based on the FBI's investigation into the Apple Watch. But they also say the Bureau of Prisons is waiting for a charging decision before starting disciplinary proceedings. Both of those statements can't be true. Either they're waiting on the investigation, or they're not. Either the process is delayed because of the government's ongoing case, or it isn't.
Mr. Banks' defense team has a growing concern that his prolonged solitary confinement may implicate the 8th Amendment prohibition on cruel and unusual punishment, U.S. Constitution amended, 8?
Some people close to the case believe there's a simpler explanation. The prison officials are angry. They want to know who gave Durk that Apple Watch, and he's not telling them. So this isn't about security or due process anymore. It's about making him suffer until he gives up a name. Think about it. An Apple Watch shows up. It gets confiscated. But instead of handling it through normal disciplinary channels like they would with any other inmate, they throw Durk in solitary for over 4 months. They lie about conducting reviews. They give conflicting explanations. They drag their feet on the hearing he's supposed to get within days. That's not security protocol. That's retaliation.
They're on a revenge tour in that prison. They feel some type of way about that goddamn Apple Watch being caught. They don't know who, because Durk ain't snitching on the person who gave it to him.
G. Herbo, one of Durk's closest friends from Chicago, tried to reassure fans about his mental state. He said he spoke to Durk a month or 2 ago, and if you know him, you know he's good. Called him disciplined, mentally strong. But even mental strength has its limits. Durk cut his signature dreadlocks. The hair he'd worn for years, part of his identity, gone. People who've been paying attention see that as a sign of the stress he's under. When you're locked in a cell 23 hours a day with nothing but your thoughts, even the strongest minds start to crack. Meanwhile, Durk tried to stay connected to his fans the only way he could. Back in March, 5 months into his incarceration, he released Deep Thoughts, an album recorded before his arrest. It featured Jhené Aiko and Future. But without the artist available for promotion, without interviews or social media engagement, the rollout was muted. While Durk's been fighting to maintain his sanity in isolation, his co-defendants have been trying to delay the trial again. January the 5th, 2026, DeAndre Dontrell Wilson, David Brian Lindsay, and Asa Houston filed their third request to push back the trial date. They're asking to move it from January 20th to May 4th. Their reasoning: the case is complex. There are scheduling conflicts. The discovery is massive. Hundreds of gigabytes of digital material, surveillance footage, over 30,000 pages of documents, witness statements, medical records. Durk didn't join that request. He's refusing to waive his speedy trial rights. He wants this over. He wants his day in court. He's been locked up since October 2024, with nearly half that time spent in solitary confinement. But here's the problem. Because they're all being tried together, if the court grants the delay for his co-defendants, it applies to everyone. Durk could want the trial to proceed, and it won't matter. So now he's stuck waiting in a 6x9 cell, waiting for a disciplinary hearing that should have happened 4 months ago, waiting for a trial that keeps getting pushed back, waiting for answers about why he's being treated this way when federal regulations say he shouldn't be. The government claims they have no position on the defense's request for a status hearing. No position. After 131 days of solitary confinement based on conflicting explanations and fabricated review claims, they have no position. Durk's case was already serious before the solitary confinement allegations surfaced. He's facing federal murder-for-hire charges connected to a 2022 shooting in Los Angeles that killed Saviaya Lulpab Robinson, Quando Rondo's cousin. Prosecutors allege Durk helped plan and fund the attack as retaliation for King Von's death in 2020. He's pleaded not guilty. He's been denied bond multiple times because of flight risk and the severity of the charges. And now, on top of fighting a case that could put him away for life, he's fighting just to maintain his mental health in conditions that research shows can cause permanent psychological damage. This isn't about whether he's guilty or innocent of the charges he's facing. That's for a jury to decide. This is about whether the system is following its own rules, whether an inmate accused of having an unauthorized device deserves 131 days in solitary without the hearing he's legally entitled to, whether prison officials can lie about conducting reviews and offer contradictory explanations without accountability.